Kath is a lawyer and she was admitted as a solicitor by the New South Wales Supreme Court last year. She co-founded Save Women's Sport Australasia with a group of women in New Zealand in 2020 when it became apparent women's sports in both countries were under threat in similar ways. Kath chooses to openly fight this battle to defend the lawful sex-based rights of her 3 little girls and all women everywhere. Her topic today, when fundamental human rights conflict.
Thank you, Anna. Right, so we are in the middle of a collision of fundamental human rights. In a modern liberal democracy, when conflict arises between 2 groups, we normally use discourse, debate, and discussion to resolve the problem. In 2019, it couldn't have been plainer that the Religious Discrimination Bill was part of the legislative omnibus for the Morrison government. Those who ran as endorsed candidates for the Liberal Party campaigned expressly or implicitly for the RDA. That was part of the party's campaign platform. Yet 5 Liberal Party members crossed the floor. And I would like to add, I do have absolute support for a proper conscience vote. It's a cornerstone of our democracy. But there's a step that has to be taken first. That is the party room. All policy debates are had there. That is where these issues are ironed out. So when legislation is brought to Parliament, the concerns have been voiced, discussed, and compromises made. Better thought out and better planned, rather than MPs crossing the floor in the middle of the night on amendments moved by the Central Alliance Party. But the strange thing is, those 5 members crossing the floor did so because they believed it was discriminating against trans kids. Kids we recognise as confused and misled by identity politics, traumatised girls abandoning womanhood, kids who are gender non-conforming, likely to grow up to be gay or lesbian, convinced they were born in the wrong sex and have the wrong body, seeking refuge from a highly gendered society that was actually doing quite well in accepting gender non-conformity. So how does it serve these kids to push them down a medicalised path or play the game of willful pretend that they are the opposite sex? How does that help them? So on the one hand, we have religious schools seeking to maintain their right to offer single-sex education and amenities to students on the basis of biological sex and not how well a student conforms to gender stereotypes. So we have a conflict. Is it going to be gender identity or sex? Should religious schools have the right to single-sex provision? Why can't children simply express themselves in defiance of their sex without single-sex provisions being undermined? Which situation is going to take precedence? Because when we look at the research, it clearly demonstrates that girls have better academic outcomes when school is single-sex. And girls not only prefer single-sex sports, PE classes and outdoor education, this is demonstrated by their participation and level of involvement, which increases when this is the case. It is unreasonable to expect girls to be denied the opportunity to excel because a boy wishes to perform opposite sex stereotypes. This is a precise example of why we need to have a proportionate and appropriate response to conflict of rights. Reasonable debate, assessment of credible evidence, genuine input from the public, and a transparent decision-making process. Consideration of the viewpoints of all stakeholders. And it must be noted that the weight of the testimony of all stakeholders is not equal, but it should be equitable based on their existing rights and the impact on the existing rights of others. This is how we usually resolve conflict of rights. So anti-discrimination law and policy in Australia rests on a complicated system of state and federal legislation, each purporting to do something different. Inconsistencies in all these acts make it very difficult to harmonise, not only for the ordinary people, but all the way to the High Court of Australia. So despite the brazen disarray caused by the Liberal Party members crossing the floor, and although religious freedom has more express constitutional protection than gender identity, and defying the argument that gender identity has no constitutional validity, we have a situation where gender identity is currently wielding extraordinary influence over Australian law and policy. So watching the debates around the religious discrimination bill and the subsequent media coverage, I think to myself, this is the inescapable consequence of reforms to the Sex Discrimination Act by the Gillard government in 2013, when Labor legislated to remove the legal definitions of men and women and insert gender identity. And it's going to take High Court cases to resolve this collision. Thank you, Sal. So, the genesis of the reforms to the SDA are unconstitutional because the Act was to give effect to the treaty, CEDAW, specifically for women and girls, to protect women and girls due to the nature, the inescapable nature of our biological female sex. Yet that treaty and other international instruments referred to in the legislation are simply silent on gender identity, intersex, and sexual orientation. So the SDA was made pursuant to the treaty's power, the treaty that concerns itself with women and girls. There is no constitutional power to legislate on gender identity, intersex, or sexual orientation. So it's ironic to have more express constitutional protection for religion than gender identity, and yet we are embroiled in a situation where in practice our rights as women are under threat. And this is in defiance of the legislation that was specifically enacted to ensure women were able to participate free from discrimination in public life. Now, I want to clearly articulate that I do not believe anyone should be discriminated against, denied opportunities, or subjected to less favourable treatment on the basis of their sexual orientation, or if they have a disorder or variation of sex development. I think no fair-minded person would disagree. However, using the SDA to provide statutory protections for these groups is not appropriate because the SDA is specifically for women and girls. And as we can see, that these other categories have been used as a Trojan horse to slip in gender identity. So we find ourselves dealing with interference in striving for balance to protections for religious freedom, which is a human right and the only one not yet covered by Australian anti-discrimination legislation, with needed protections for gay and lesbian people and protections for women based on their biological sex. And trumping it all is gender identity. And the legislative definition of this is so vague and nebulous that it almost means nothing, except mannerisms, appearance, or how you would like to be identified, which these days could even be a cat, as in cat gender or meow gender, now both protected identities at Bristol University. So if it's confusing for legislators and lawyers, it's certainly confusing for the ordinary people trying to make sense of it. And compounding this convoluted state of affairs, women are called TERF, bigot, transphobe, racist, homophobe, when we speak up to defend the SDA, when we speak up in defence of our sex-based rights, language and fair competition in sports, and the sanctity of female-only spaces. So women requesting a transparent and robust debate in the public domain are left to deal with unfounded accusations to discredit our legitimate view. And this distracts from the validity and credibility of our position. And as I actually discovered today, our presence in debates that actually are able to occur make other people feel unsafe, and people like me are apparently the ones sending rape and death threats. So one word for that to those people: projection. So we are cancelled, deplatformed, banned for life from social media, livelihoods attacked, reputations smeared, rape and death threats are made against us and our children, and some of us have even been assaulted. Why? Because those who seek to silence us want to distract everyone else from the insidious and stealth erosion of safeguards for women and children. They don't want everyone to notice they are stripping biological sex from foreign policy. It's a systematic destruction of women's human rights. Because if rights and spaces and resources are allocated on the basis of identity, and to do so on the basis of sex is now unkind, bigoted, discriminatory, or even unlawful, then women will no longer be able to be recognised as a category worthy of protection on the grounds of our sex. Our sex-based rights will now be judged on identity, mere gender, and men and boys will be able to access their protection, rendering them meaningless. We will no longer have spaces free from biological males. We will no longer have resources allocated specific to our needs. We will no longer be recognised under law. Women's rights will evaporate for this generation and future generations of women and girls. We must fight to protect them now, because if we lose them, it will be exponentially harder to get them back. So this brings us to Senator Chandler's bill. It will deliver clarity to this issue with this conflict of rights. We will have certainty in the knowledge that women and girls will have a lawful choice to play in a category that is consistent with their physiological status. Ordinary definitions for man, woman, and biological sex will be restored. This is the only way to ensure a level playing field for women and girls in sports and in society. We simply cannot sacrifice women's rights for the rights of another group whose demands are undermining our own. And Senator Chandler's bill is seeking to restore that. Because look at what happens when we allow gender identity to dominate. The scandal of UPenn swimmer Leah Thomas and the immediate capitulation of the Ivy League. The obsequious fawning and making sure that Thomas feels safe and protected. The contempt shown towards the concerns of the girls, the farce of the unfair competition in which they must participate. Because the girls don't have a consolation category, they don't have a plan B when ranking 452nd isn't cutting it for them. Because make no mistake, Thomas doesn't feel unsafe. Thomas is now a celebrity and a household name. Thomas can probably make a lucrative career for themselves as a trans consultant or a trans motivational speaker or a trans sportscaster. Look at the Sports Illustrated cover that just came out. And I did note that whenever you look at women on that cover, even if they're Naomi Osaka or one of the Williams sisters, they're always looking sultry, in a bikini, and the men are always wearing their uniforms, doing their sport. Having a look at the picture of Leah, I'm wondering why Leah isn't in a sultry bikini. From the testimony of the Penn swimming mother, it is obvious Thomas does not care about the destruction left in their path. He doesn't care that the girls are left demoralised and disillusioned, that they and their families have been gagged. Doesn't care if they'll be banished if they exercise their freedom of speech, risking scholarships and future career opportunities. He doesn't care that the presence of his intact 6'4" male body in the change room is now subjecting these girls to state-sanctioned sexual abuse. Because if those girls are told they always have a choice whether or not they undress in front of a male, where does she go? The janitor's closet? The car? The gender-neutral toilet cubicle? And as for the Ivy League, grudgingly admitting women only to their hallowed halls only in the last 50 years, one has to wonder how the female students feel now that they know their rights are so precarious and they only exist because the dominant power structure grants them. But as Coach Blade on Glinner pointed out, those girls are defiant. They did resist by joining hands, and one day those girls will go out into the world armed with their expensive degree and hopefully fight the good fight. Seems to be a recurring theme here, but weaponising state apparatus to settle personal grievances or silencing people is nothing original. It's been used in totalitarian and authoritarian regimes throughout history. The entirety of the history of burning women as witches, removing disobedient women, more legible women, barren women, beautiful women, frigid women, defiant women, women you just don't like. This is just the contemporary permutation of it. So we find ourselves in a peculiar position of a conflict of rights, where we women are having our rights systematically stripped and reduced. Yet talking about it is verboten, and if we dare to do so, we risk sanction and punishment. And to compound the entire situation, we are told that those who benefit from the destruction of our rights are the most oppressed, the most vulnerable, and the most vilified. It defies reality, it defies common sense, and it defies how a functional liberal democracy should deal with the conflict of rights. So Professor Camille Paglia said that historically, the movement towards androgyny occurs in late phases of culture as a civilization is starting to unravel. You can find it again and again and again through history in Greek art. All of a sudden, the sculptures of male athletes, which used to be all robust, all of a sudden begin to seem like a wet noodle. The people who live in such periods in late phases of culture feel as though they are very sophisticated and cosmopolitan. Homosexuality, heterosexuality, so what, anything goes. But from the perspective of historical distance, you can see that that's a culture that no longer believes in itself. So do we really want to find ourselves hurtling towards the end of civilization? Do we really want this to be the end for women and girls? So we must address this conflict of rights. We must resist the erasure of sex at all costs. Because if we allow gender identity to supersede sex, if we allow reality to become hostage to ideology, history tells us that this foreshadows the end of civilization. We have the opportunity to turn this around. Our understanding of historical cultures allows us to have the foresight to avoid this unravelling. So being here today, speaking the truth and refusing to deny that biological sex does not matter, demanding the opportunity to have the debate to resolve this conflict with measures that are proportionate and appropriate and not simply capitulation or destruction, this is the way we defend sanity and reality. This is how we preserve and keep safe women's rights for future generations of women and girls.